dream I know, deep up my feelings for you. Watch.
The headlines. Supreme Court dismisses Atiku's appeal against President Bola Tinubu. Before I proceed with the news, welcome to Reality Latest Gist, your home of news and politics. Thank you all so much for joining us on today's news. If this is your first time of watching, please do us a favor to like and subscribe, and also turn the notification bell to get notified when next we drop our video, because I'm sure you don't want to miss out on the trending and latest news happening on social media. To all our amazing returning subscribers, thank you all so much for staying tuned with us. We really do appreciate. To all our viewers out there, feel relaxed, enjoy and stay tuned. Now on the news, the Supreme Court has dismissed the appeal by former Vice President and presidential candidate of the People Democratic Party, Atiku Abubakar, seeking to nullify the February 25th presidential election of President Bola Tinubu. In a unanimous judgment, the appellate dismissed Atiku's appeal for lacking merit, and such affirmed the judgment of the Presidential Election Petition Court, which affirmed the election of President Tinubu. In the notice of appeal, Atiku had urged the appellate court to dismiss and set aside the September 6 judgment of the Presidential Election Petition Court, which affirmed the electoral victory of President Tinubu. A 7-man panel of justice led by Inec in determining the first issue for determination held that failure to transmit election results electronically did not affect the outcome of the election and could not warrant cancellation of the presidential election. The appellate court also stated that Atiku did not produce alternative results of the presidential election that shows he won majority of lawful votes cast to dismiss the one declared by electoral body Inec. The court resolved all the 7 issues distilled for determination in favor of President Tinubu, stating that the appeal lacked merit. So guys, join me as we take a look at the video. And please don't forget to send in your comments and also keep the conversation lively in our comment section. Let's take a look.
It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable and cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petition. Let me say it clearly that 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act. This principle was again restated by yet again Onogen JSC as it was in NNPP and GONI. Citation supplied when he said, despite the decision of this court since October 2011 on the time fixed in the Constitution, some of the justices of the lower court still appear not to have gotten the message. From where will the election tribunal get the jurisdiction to entertain the retrial after expiration of the 180 days assigned by the Constitution? The answer is obviously in the negative. It should be constantly kept in mind that prior to the provisions of Section 285(6) of the 1999 Constitution as amended, there was no time limit for the hearing and determination of election petition by the election tribunals or the appeals arising therefrom. That situation resulted in undue delay in the hearing and determination of an election petition by the election tribunals or appeals arising therefrom. The amendment to the original Section 285 of the 1999 Constitution, by allotting time within which to hear and determine election petition and appeals arising therefrom, is designed to ensure expeditious hearing and conclusion of election matters. If the decision of the lower court is allowed to stand, as urged by the respondents, it will reintroduce the earlier mischief which the amendment sought to correct. End of quote. See also OBI and Shùtdòwn. Citation supplied. The above statement by this court is very explicit, clear, and simple. As it is, the provision of the Constitution has spoken. There cannot be an addendum or another reopening of the case at the lower court, its jurisdiction having lapsed. My noble lords, I've taken time to state the law on the issue to show the futility of this motion. It cannot be granted. The jurisdiction of this court is donated by the Constitution and the Electoral Act regarding election petition appeals. We do not have the virus to admit this position, and we cannot invoke Section 22 of the Supreme Court Act, since the lower court has since lost its jurisdiction. More so, there is no paragraph of the petition to accommodate a case of forgery. Again, the appellants have distilled 7 issues for the determination of this appeal, and none relates to certificate forgery. One wonders what the appellants intended to do with the deposition, since appeals are heard on the issues distilled for determination by the parties in this court. In Saliba and Jackson, 2002, for Nigeria Law Report, citations others supplied, this court stated clearly that all appeals are decided upon the issues formulated for determination. What this means is that any matter not covered by any issue for determination is of no moment. Should the deposition be admitted, it will float in the appeal, as this court cannot exercise original jurisdiction even if we are to start a new case for the appellants. See Sanusi and Ayula, Kitex Industries, and Oceanic Bank, citations supplied. Finally, my noble lords, on this application, I wish to state that fresh evidence is not received as a matter of course. There are conditions which must coexist before the court can grant this type of application, as can be garnered from the decided authorities of this court, which include, but not limited to Onwu, Buariri, and others, and Igbo, Oyosi, and others, Supra. Adegbite and a motion are cases cited by the senior counsel by the second respondent. Simply put, the conditions for the grant of this type of application are that 1, the fresh evidence could not have been obtained with reasonable diligence at the trial. 2, such evidence, if admitted, would have important effect on the subject of the appeal. 3, such evidence ex facie is apparently capable of being believed. 4, such evidence would have influenced the judgment of the lower court in favor of the appellants had it been available. And 5, and if such evidence is admitted, further evidences from the opposing party would not be needed. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said deposition sought to be admitted in this court.